Thanks for watching this video brought to you by AN Immigration Services and Consulting. Please ensure that you watch this video at high resolution for best video quality, as we are going to walk through the application process and the eligibility criteria in applying for a Subclass 186 Employer Nomination Scheme visa under the Direct Entry stream. At the end of this video, we have provided links to some legislative instruments related to this visa for your easy reference. The information in this video is only intended for primary visa applicants who want to apply for a Subclass 186 visa under the Direct Entry stream on or from the 12th of April 2024. This visa lets skilled workers, who are nominated by an employer, live and work in Australia permanently. The content in this video is for reference only. Please seek professional advice about the content in this video. Although this video is just over 10 minutes long, many hours of work have been spent on depicting the complex legislative requirements in full for this visa in a format that visa applicants can follow and understand easily and visually. Please like and share this video and subscribe to our channel. Let us be part of your journey in Australia and support you throughout this journey. Let's start. The red lines in this flow chart are answers no to the question in a decision step. Please commence from start at the top, answer the questions in each decision step and follow the direction of the arrows to guide you through the detailed application process and eligibility criteria. There are 2 steps in applying for this visa. The first step is to submit a valid visa application. If your application is not valid, your application will not be considered even if you satisfy all eligibility criteria. For any visa applications, always check whether there are any visa conditions, act-based or regulation-based restrictions that will stop you from applying for the visa. There may not be such restriction, or the restrictions may not apply to you. However, it is the awareness of any restrictions and waiver that is important. For example, if you currently hold a visa with condition 8503 or 8534 attached, this visa condition will prevent you from applying for this visa in Australia. However, a waiver for this visa condition is available under Migration Regulation 2.07 AG. You need to lodge an Internet application using Form 1408. Unless you are nominated as a Minister of Religion by a religious institution, visa application charge is payable. The visa application charge is $4,640 as of the 12th of April 2024. You need to declare in the application that the position is the one nominated under the Employer Nomination Scheme Direct Entry nomination provisions under the Migration Regulations 1994. You also need to declare whether or not you or any accompanying family members have engaged in any prohibited sponsored related conduct. For example, if you offer a sum of money to induce a person to nominate you for a proposed occupation in a visa application, this is a prohibited sponsorship conduct. You can either apply for this visa in or outside Australia. If you apply in Australia, you need to hold a substantive visa or a bridging A, B or C visa. A substantive visa means a visa other than a bridging visa, a criminal justice visa or an enforcement visa. The second step is to check whether you satisfy all eligibility criteria at the time of decision of your application. If registration, licensing or professional membership is mandatory for you to work in the occupation in the state or territory in which the position is located. At the time of visa application, you must hold, or be eligible to hold, the relevant registration, license or membership. The position to which the visa application relates must provide you with the employment referred to in the nomination. You are required to provide the employment contract as part of your application. You have not engaged in any prohibited sponsorship conduct in the previous 3 years unless the department deems it reasonable to disregard such conduct. If you currently hold, or your last substantive visa held was either a subclass 491 skilled work regional provisional visa or subclass 494 skilled employer-sponsored regional provisional visa, you must have held that visa for at least 3 years at the time of application. There are various public interest criteria and special return criteria that you must satisfy, including the character and health requirements. Any accompanying family members included in your visa application also need to meet these criteria. Public interest criteria also apply to any non-accompanying family members. These criteria for the family members to satisfy are called one fails, all fail criteria. This means that if any accompanying or non-accompanying family members do not meet these criteria, your application will be refused. You need to have competent English to apply for this visa. If you do not hold a passport issued by the United Kingdom, the Republic of Ireland, United States of America, Canada or New Zealand, you need to have undertaken a specified English language test and achieved the required scores. One of the more well-known specified English language tests is IELTS. Information about other specified English tests and the required scores are provided in a link at the end of this video. Also, the test must have been conducted in the 3 years immediately before the date of application. Unless you are an academic applicant, a science applicant, a subclass 444 or 461 worker, you must be under 45 years of age at the time of application. Please refer to the relevant definitions of such categories of applicants if you want to take advantage of this age exemption. These specified applicants are also exempted from skills assessment. At the time of application, your skills had been assessed as suitable by a relevant assessing authority for your nominated skilled occupation. 485 temporary graduate visa skills assessments are not acceptable in relation to this visa. It is important to note that assessing authorities may set different standards for skills assessments for the same occupation. Temporary and permanent visa programs may have differing purposes, and the different standards of skills assessments reflect those purposes. For example, a 485 visa is aimed at assisting a graduate to gain skilled work experience in Australia. A 186 visa is aimed at an applicant who already has relevant skilled work experience in the relevant occupation. The standards for a skilled assessment for a provisional and permanent visa such as the subclass 186 visa will therefore generally be at a higher level. Please note that membership with an Australian professional society is not a substitute for skills assessment. If there is validity period for your skills assessment and the period does not end more than 3 years after the date of assessment, the period has not ended. If this requirement is not met, not more than 3 years had passed since the date of your skills assessment. In terms of years of experience, you are required to have been employed in the nominated occupation on a full-time basis with at least 3 years of post-qualification experience. There is no adverse information about the nominator or its associates unless the department deems it reasonable to disregard such adverse information. Adverse information is any information relevant in determining a person's suitability as an approved sponsor or a nominator. For example, the department may receive a tip-off about your nominator having contravened a law of the Commonwealth, a state, or a territory. The discretion to disregard the adverse information depend on many factors, for example, the nature and seriousness of the adverse information. Your employer or prospective employer is also the nominator of your position. The nomination has been approved and has not been subsequently withdrawn. Your visa application is made not more than 6 months after the nomination has been approved. The nomination identifies you in relation to the position and is made in relation to your visa application under the direct entry stream. The position is still available to you and is the one nominated under the Employer Nomination Scheme Direct Entry Nomination Provisions under the Migration Regulations 1994. The tasks of the position must be performed in Australia and correspond to an occupation that applies to you and is specified in a legislative instrument that was in force at the time of application. We have included a link at the end of this video to the legislative instruments showing the occupations that are currently specified as skilled occupations, and these occupations are relevant to your application. Thanks for walking through the application process and the eligibility criteria with us. Please like and share this video and subscribe to our channel so that we can provide more content to support you.